next topic is one that will not make things any clearer, but it will be interesting. And it is a discussion of the ecosystem approach, which, as far as I can tell, everyone seems to be in favor of, but not everyone is certain what it means, including our legislators. Our speaker has a really interesting multi-jurisdictional perspective on this. Mike Wenig has worked for the federal and state governments in the United States. He has worked in private practice in both countries. He has formerly acted as my colleague, as a research associate with the Canadian Institute of Resources Law, and where he did a lot of work on ecosystem management. And he is currently with the Natural Resources Conservation Board of Alberta, so he's covered a lot of waterfront, and I'm very happy to welcome back to the law school. Mike.
Great, thanks, Owen. It's a pleasure to be back here. I was here as a grad student and employee. I wasn't just Owen's colleague, he was really my boss. But anyway, it was still a good relationship, and I'm happy to be back. I should say, because I do work for the Natural Resources Conservation Board, I should make clear that the views in my paper and that I express here are my own personal views, not those of the NRCB necessarily, and any errors, of course, are my own. So I suppose ecosystem management, as Owen hinted, is kind of like sustainability or sustainable development. There's lots of different concepts floating out there of or definitions of what these concepts really mean, and sort of people competing for for their definitions. So my concept of ecosystem management may not actually coincide with what some of you out in the audience think what you may be doing as ecosystem management. My approach in the paper and today is basically to try to find the lowest common denominators, the things that all the proponents of ecosystem management seem to agree on, and then to identify the areas of disagreement or the areas of uncertainty. I should note right at the outset that in Cindy Chasson, in her paper on cumulative effects management, has a good description of a regional planning process in northern Alberta, which may well be one of the sort of cutting edge or leading edge examples of ecosystem management as far as it goes. Because of my current job, I'll leave it to Cindy to critique the provincial regional plan, so I won't do that, but I do recommend that you read that for a good example of sort of leading edge ecosystem management approaches. I was noticing, just as another preliminary matter, the sort of the order of topics, and we started with legal concepts of sustainability, which I think everybody would agree is kind of a meta principle. It's pretty high up there among the hierarchy of principles. And then we get to precautionary principle, which I would submit is still kind of it's kind of a baby meta principle or a quasi meta principle. It's down below precautionary principle somewhere, but not quite down on the ground. And then we get to ecosystem management, which raises the question, well, does that mean it's sort of even below precautionary principle? And I think there the hierarchy fails because ecosystem management, as I understand it, is really sort of a smorgasbord of a lot of things, including some pretty high meta principles, philosophical notions, conceptual ideas that are at the meta level, but it also includes notions of fairly hands-on kind of technological approaches. So one other preliminary point. There's been I don't know if any of you noticed, but there's been a kind of a running tug of war between me and I presume Owen as to what it is actually that I'm talking about here. Owen called me up and asked me to talk about ecosystem approaches, which I didn't think too much about, his terminology at the time. And I keep using the term ecosystem management. And we've gone back and forth, and even after I wrote my paper, I see the program still refers to ecosystem approaches, so we're still having this tug of war. And it's a good one. It raises a good point. To some, the term management implies a kind of a technocratic, utilitarian, and particularly an anthropocentric approach. So in that sense, using Owen's description of the term sustainable development, I suppose you could say the environmentalists got the ecosystem and the developers, or maybe the bureaucrats, got the management part. So what's the alternative? And Owen's alternative, I guess, is ecosystem approaches. And I agree with the conceptual issues that going away from management raises. They're good issues to address. But for me, there's just a practical problem. Whenever I hear ecosystem approach, I always think ecosystem approach to what? What are we actually approaching? And when I think about that a while, I always think, well, it's really ecosystem approaches to management. So it's just shorter, it's easier for me to refer to ecosystem management than to say ecosystem approaches to something else. But just to be clear, for purposes of my paper and for this discussion, my concept of management is pretty basic. I'm really referring to the core function of decision-making by public officials who are responsible for environmental protection, public lands, and natural resources. And I think under any concept, anthropocentric, or if you could have a non-anthropocentric view of an approach, at the end of the day, you've still got to have decision-making by public officials who are in environment agencies or in some agencies responsible for natural resources. So we've covered the management part. Now what about the ecosystem part? And of course, as the term implies, this is kind of the key focus, the key target or characteristic of the management. So what is an ecosystem? And there are, I think, lots of different definitions kicking around but I think they're all relatively similar from the scientific point of view. And the one that I cited on page 5 of my paper is an ecosystem is an assemblage of species plus the interacting physical and biological processes upon which the species depend. So I went to the internet to see if I could find an assemblage of species plus the interacting physical and biological process, and there are lots of hits for the search ecosystem diagram. And lots of them are very schematic, like really, really complicated stuff that I couldn't pretend to try to explain. But I came upon this one, which is relatively simple, which even a non-scientist like me can get. So we've got our assemblages of species here, and we've got arrows showing connections between these species. And then we've got our sort of physical processes, gravitational pull, we've got deep ocean currents, and we've got our sort of physical characteristics, and we've got inputs, precipitation from outside, and inputs, solar energy. So this is sort of a basic kind of ecosystem. So what's the key aspect of this? What's kind of the take-home message from this diagram? And for me, the message is, and again, this is in my sort of ecosystem for idiots sort of level of lingo, it's a message that you've all heard before. Everything is connected. You can't, if you're thinking about this critter, you really got to think about how it relates to these lower down in the food chain, how it relates to these other physical processes, and the physical area around it. So everything's connected. So what does that mean for ecosystem management? Well, what it means is the focus is on, when we focus on ecosystems, we're really taking a holistic approach. We're looking at all these components, all these connections. It's interdisciplinary in the sense that we've got the biologists worrying about the critters here, we've got chemists worrying here, we've got physicists worrying about deep ocean currents. It's really a multidisciplinary approach, and it's a systems approach. You put it all together, and we're really talking about a system. So why bother? What's the point of having this kind of approach? And I think it's probably pretty self-evident, but just in case it isn't, the idea here is that if you're going to address one component or one environmental component or one particular resource, you've really got to look at all the different things in a given system that affect that resource. So, traditionally, if we were worried about fish in there, so this is a diagram of a watershed ecosystem. Watersheds being defined as an area of land drained by a given body of water. So if we're looking at protecting fish in the river, in the old days, we might just, the wildlife biologists would worry about how many fish are being caught, and then the pollution managers would worry about pollution from a given point source, say the industrial facility. But under an ecosystem management approach, you've got to say, hey, if we're really going to protect the fish, we've got to think about habitat along the riparian zone. We've got to think about horizontal interactions between the river and what's happening in the uplands adjacent to the river. We've got to think about all the possible sources, not just the point source, but the non-point sources, runoff from agriculture, runoff from urban areas. We've got to combine all these sources. We've got to think in a cumulative effects management approach, which is a linkage to Cindy's paper. So ecosystem management is essentially cumulative effects management at an ecosystem scale. And we've got to worry about these vertical linkages, the linkages between surface water and groundwater. And then vertical going up, we've got to worry about what's coming in from outside. So that's the need. And then while we're sort of thinking about that, we come to the realization that, well, maybe we shouldn't even be focused on a particular resource like fish and looking at the entire ecosystem as it affects fish. Maybe we should be thinking about the entire ecosystem itself as our target for protection or a target for our management efforts rather than just a single species. And why? Because when we think in system terms, we come to realize that there are all these benefits that we get at a system level beyond what immediate benefits we might get from fish or fish's right to exist in and of themselves if we're taking a non-anthropocentric view. So we really got to think about ecosystems themselves as our target for protection. So okay, that's essentially the imperative. That's the why we have to do it. And I think Owen hit the nail right on the head. It's pretty hard to argue against that kind of imperative. It's pretty hard to argue, that we shouldn't consider all the effects and the sort of the cumulative system-wide perspective. But what's the catch, or what are the challenges? And so there's several that I referred to in my paper, and I'll just summarize them quickly. One is that it's the concept of an ecosystem sort of makes sense scientifically, but the boundaries of ecosystems are essentially arbitrary. They're human constructs. And so here we have a watershed ecosystem. Well, that all makes sense. This is the area that's drained by this river. But if you look at the fish, if it's a migratory fish that then goes out into the ocean and swims around the ocean for a few years and comes back, why aren't you looking at the assemblage of species relating to that fish through its entire migratory path? And if there's wild geese coming in, they have their own assemblage of species that they're connected to outside of this watershed. And the other problem is that that each ecosystem is not self-defined or self-contained. We've got snow, we've got sunshine coming in, we've got atmospheric things happening to this particular ecosystem, and here this diagram shows precipitation. This is coming from somewhere else outside of the watershed. So the question for managers is, how do you define ecosystem units in a functional way so that you can get on with your management? And there are various approaches. I've referred to a few in my paper, but I think it's safe to say that there's no sort of silver bullet, there's no easy answer, and we're still kind of struggling with how to do that. Another problem is that the essence of the ecosystem approach or ecosystem management is its holistic, multidisciplinary characteristic. But the more holistic you get, the more interdisciplinary, the bigger the system you're looking at, the more darn complicated it is to figure out what all is actually going on. And so it creates what we refer to as a paradox. You really want to be holistic, but the more holistic you get, the harder it is to actually figure anything out. So another problem that I mentioned in the paper is really more of a kind of a conceptual problem. And it's a problem at least to the extent that it generates a lot of play in the ecosystem management literature. And that is, if you start to look at resources as part of systems, raise the question, well, what about us? What about people? Where do we stand? Are we in or are we out? Are we part of an ecosystem or are we not? Or do we just sort of look down on the ecosystem as managers and kind of, tweak a few things here and there, but we're really sort of separate from it? And believe me, this debate sort of rages on. It gets a lot of play, as I say, in the literature. And, I'm not going to go into all the details of it. Frankly, I'm not completely sure of what the significance of it is at the end of the day. I'm not sure personally whether if you tried to take one approach as opposed to another approach, you'd really come to different results. So I'm still a little confused as to the implications of the debate, but there you have it. But I think it does raise, or at least relate to one issue that I think is a concrete issue, which is, and this was raised in the sustainability presentation and paper, which is a healthy ecosystem or some desired condition of an ecosystem sort of one of many factors for managers to consider in deciding whether to allow development, for example, or what level of human activity, or is it really sort of a bottom line which can't be altered? And so really, once we take that bottom line, then our mission as managers is, and humans, is just to figure out how to maintain our activities in a way that sort of sustains that bottom line, otherwise known as carrying capacity. And I guess you could say this debate about, whether we're in or out raises the question of the, are we really taking an anthropocentric or non-anthropocentric view of ecosystem management? And I'll leave that sort of ethical issue to the paper on legal ethics. So, okay, those are some of the main challenges. What are some of the aspects, or what are some of the areas of ecosystem management where there's some disagreement, where there are sort of components that we all know need to be included, but we're not really sure what those components should look like? Well, one of them relates to governance. What are the governance mechanisms for ecosystem management? And I think everybody agrees that because of this holistic interdisciplinary approach that involves lots of different resources, lots of different system components, we need to have a high level of coordination among all the managers. And so, okay, that, everybody can agree with that, but then the question is, how do you actually do that, on the ground? So, do you get them all to just come together every once in a while for meetings, or do you actually reorganize agencies or departments so that all these people from various disciplines and responsibilities for different resources come together and actually try to work together, sit in the same room all the time and sort of start thinking like an entire system? And there's one example of that which comes to mind, personal, because it relates to my wife, who used to work and still works for the U.S. government in Alaska. And when she started working there, she was a wildlife biologist for the U.S. Fish and Wildlife Service. And at the time, the U.S., that agency had all the managerial biologists and the research biologists. But when this whole sort of ecosystem management craze really hit the ground running in the 90s, the decision was made to take the research biologists out of the Fish and Wildlife Service and put them with the geologists and other physical scientists in the U.S. Geological, it's either survey or service, I keep forgetting. And one of the ideas, I think, was to promote sort of ecosystem thinking by taking scientists from different disciplines and putting them all together. And I think the record there is mixed. You've now got them all under one agency, but are they really starting to kind of think like an ecosystem? It's there's kind of a mixed record there. Another aspect of governance is what do the public officials as managers do in relation to non-public officials? And how do they relate? Is there any difference in their relation under ecosystem management than there is under some other kind of environmental management approach? And I think there's a consensus that yes, there is something different with ecosystem management. There's a much more collaborative approach with local residents living in the ecosystem unit of choice and with other stakeholders. And so there's essentially much more participation, public participation under an ecosystem management approach. So, okay, there's a sort of general consensus on that, but, what does that really mean at a practical sort of level? Who does what? Who gets to make the calls at the end of the day? What kind of input do you get from the public? Are they deciding the priorities for that particular ecosystem? Are they setting the goals? Are they, or are they just recommending solutions? Are they just making recommendations, or are they actually making decisions? And so there's still a lot of open question and uncertainty about what the relative roles are of the government officials and the non-government officials. Another big question is, what's the point? What's the objective of ecosystem management? Is it more just sort of a procedural framework, a way of looking at problems, or does it really imply a goal? And I think there's still a split in the literature among the ecosystem management proponents on this one, or at least among the practitioners and the proponents, or the academics. And there's a lot of people who say, no, ecosystem management really implies an end result, which is a protection of a certain condition of ecosystems. There's actually even inconsistency as to how you define that desired kind of condition. Sean Fluker is presenting a paper on ecosystem integrity, so that's one phrase, but as I pointed out in their paper, there's other sort of ways of referring to a good, an ecosystem that's in good condition. But the other approach is to say, well, no, we're not implying any kind of end result. All we're saying is we're going to look at problems from an ecosystem perspective, but let's let the people who are working on those problems define what their end result should be. So related to that problem is the question of, okay, what tools are we actually going to use to achieve our desired end result? And so I think that there's general consensus among ecosystem management academics and practitioners that planning is sort of the key tool. And why is that? Well, when you're looking at problems from a system level, you really need a kind of a comprehensive tool to address all those components. And what have we got? Well, it's plans, or sometimes called strategies, but essentially it's planning at some kind of ecosystem level. Then the next question is, well, okay, we got these plans. What should we put in these plans? And the key issue there, I think, is the question of, are we going to have limits or aren't we going to have limits? And if we're going to have limits, what are they going to look like, and are they going to really be enforceable kinds of limits? And so again, I discussed that a bit in my paper. I won't go into it, but I'd say it's still kind of a big question. Cindy does a good job of talking about the limits that are being used in the Lower Athabasca Regional Plan, and I promised that I wouldn't critique them. Maybe I'll at least sort of characterize them as they're, on the sort of hard and soft scale. They're for sure not hard in the sense that they're not immediately enforceable. All they are is sort of trigger points. Once these limits are identified and then exceeded, then managers have to start hustling and doing something. But it doesn't necessarily mean, that at the end of the day, all the people who are causing an exceedance of the limit have to cut back their operations, if I have that right. So it does use limits, but not in as hard a way as some other approaches might use. And then the last aspect here, which is, I think, common to all the proponents of ecosystem management, is the notion of adaptive management, which is sort of a circular, I guess I should have a slide on this one. It's kind of a circular process where you make a hypothesis as to what you think the problem is, what's causing the problem, how you can solve it, and then you go out and implement your solution. You come up with solutions, you try to implement them, then you do a lot of monitoring and a lot of head scratching along the way, and you're continually deciding whether or not the approach that you've adopted is really the right approach. So again, who could argue with that? It seems to make a lot of sense. The problem is that it runs into the other concept of certainty, which we hear so often, that people who actually do stuff, economic actors, like to have, because you need to know what the rules of the game are. So if adaptive management applies changing the rules of the game often or periodically, that creates a headache for people who actually need certainty. So bottom line, ecosystem management makes total sense. It is an imperative at a high conceptual level, but it's awfully hard to define and operationalize. As Owen mentioned, this is sort of a running theme of the day. The other point is that we will probably never achieve a pure or sort of perfect ecosystem management model. All we can really hope for is to sort of make progress along a continuum, and keep moving further and further toward that sort of perfect model. So I'll leave it there. Thanks.
We'll take questions, and again, if you just see if this is on. It is. If you can just hand your cards to Sue here. And while you're thinking of questions, I've got one right away. Mike, you finished off talking about adaptive management, which of course is, for some time, has been, if not flavor of the month, maybe flavor of the decade. And it does make a lot of sense. And you've talked about some of the, you referred to the problems with respect to certainty, and that poses challenges for lawyers in terms of property rights and so forth. I'd like you to just maybe say a few words about how that affects judges and perhaps regulatory boards too, but especially judges in the sense that certainly in the Canadian tradition, maybe the United States has a little more experience in terms of continuing supervision by courts. But courts do like to have things off the table and settled. What kind of challenge does that pose for a judge to realize that one step in a process is just that? It may be coming back. Do we have to look at more room for things like continuing injunctions, perhaps supervisory orders of courts? How do you see that working out in practice in the judiciary in Canada?
Yeah, it's funny how 3 years working for the government and now I'm a strong advocate of deference. So the first thing that comes to mind is deference. So you could argue that rather than suggesting sort of more judicial oversight, that the concept of adaptive management warrants more judicial deference. And I think the argument would be, so here I am already thinking of sort of arguments that I might make as a government lawyer now. So I guess the argument would be, look, here are the rules, here's the regime the regulatory approach we're putting into place now, but you should know that we're putting this into place under an adaptive management framework. So it may change along the way. So if it's really going to promote a lot of hardship or create a lot of hassle now, don't worry, we'll fix it under our adaptive management. Therefore, judge, you should cut us a little more slack than you otherwise might cut us. Yeah. So that's one way of looking at it. But I suppose the people who are interested in certainty, might say, no. If we take certainty as sort of a judicial kind of principle, then if what they're saying here is that there will be less certainty, then maybe, Judge, you need to actually be more involved and take a closer look at what's really going on.
First question from the floor. Given that ecosystems are not easily defined or identified, I think we'd all agree with that, when preparing an environmental impact assessment, what factors should primarily direct the selection of the ecosystem study area? For example, the most vulnerable ecological element, the predominant impact, and I suppose one could add in there jurisdictional borders like provincial boundaries even. So,
right, so I'm not exactly sure, and I'm not a kind of an environmental assessment expert or sort of, I don't practice in that area very much, but I would imagine that you would look at your species or your resources of most concern and then think about what systems are sort of most relevant to those particular species and then define your ecosystem unit along those lines. But it may be that if you've got multiple species or multiple resources, you may have to adopt several different ecosystem units. The other approach, though, is if you're thinking about environmental assessment itself on a kind of systemic level, is maybe you as in federal environmental assessors or provincial assessors want to develop their own framework of ecosystem units that cuts across the entire geographic region that they're responsible for, whether it's watersheds or ecozones or terrestrial ecozones or whatever they are, so that they all fit together, so that when you start doing environmental assessments, you can do them in units that fit sort of systematically with all the other units in the overall area.
The next question will be, coming back to this one, I suspect, is cumulative effects assessment in environmental assessment an application of the ecosystem approach? If not, should it be?
Yeah, so as I said, it's really, I don't know whether you call it an application or kind of a flip side, but I think the way I described it before, it's ecosystem management is really cumulative effects management at an ecosystem scale. But I'll leave it to Cindy to add further detail to that question.
Cindy Chasson will be talking about cumulative effects in a lot more detail. The next question, I think, reflects a certain suspicion that is, I think, there's probably widespread to some degree in terms of what we can actually do with this, and it's the question is, what role should science play? And then it's a little more provocative than that. Currently, science is involved only superficially. The same approach in healthcare or engineering standards would be a disaster. Simple concepts and classes of management units are not science. How can real science be included, or are general concepts at the newspaper or high school level sufficient? I did say it was provocative, so. But I think the general tenor of that is one that concerns a lot of people. And it goes indeed to a point, I think, that you made, Mike, that once you get really holistic, what are you really talking about? If everything is being considered, what are you actually considering?
Okay, so that's a great question, but it does raise a few different aspects, one of which I'm really glad you gave me the excuse to address, which is your comment or the part of the question about applying, as I understand it, you couldn't really apply an ecosystem management approach to other areas like health management. And interestingly enough, in my last few years working at Cyril, I wasn't working on ecosystem management, I was working on energy policy issues and working with energy economists and engineers, but I was coming at the topic from having worked on ecosystem management. So I was bringing sort of systems thinking, as I understood it, from an ecosystems point of view to the idea of energy, and thinking about, well, okay, it's not really about electricity, it's not about natural gas or oil sands, it's really about systems. It's really about providing energy at sort of a lowest rate, so a lowest cost to society. So I had some very interesting discussions with my colleague, who'd been working in electricity regulation all his life, about sort of bringing in the ecosystem management perspective. So I actually disagree with the premise of the question that you can't really apply these principles in other areas. I think you actually get some interesting results if you do that. But I'm just sort of a systems junkie myself. But getting to the heart of the question, what's the role of science? Obviously, you need science to. I mean, there's a heightened role for science in the sense that we're now talking about all these linkages, all these connections. It's complex stuff. We need scientists to help us understand it and figure it out. But I'm not one of these people who goes around talking about science-based decision making. I mean, I think, you got to use science as much as you can, and you shouldn't abuse it. You shouldn't misrepresent what the science are saying. But at the end of the day, the decisions come down, our policy decisions, whether they can really be non-anthropocentric or not, I'm not so sure, but they're not pure science decisions. What's the acceptable level of risk of a carcinogen? That's not a purely science-based decision. that's really a policy decision. We need science to inform that. So ecosystem management is really no different than anything else. At the end of the day, we've got to decide what is our desired condition of an ecosystem that we want to achieve, what level of human impacts are acceptable, and those aren't ultimately science. The next aspect of that, though, is, can we really figure it all out? If we're trying to be holistic, can the scientists really give us that sort of big picture and the kind of more detailed picture so that we can then apply our management and policy decisions? And, I guess my answer is I'm not completely sure, and I think there are areas where it is problematic to try to figure it all out. But I think just the process of thinking along ecosystem lines, of thinking about these cumulative effects on an ecosystem scale, all these linkages, it improves our decision making. So we may never have sort of perfect science as a tool, but the more we have, the better off we are, and the more we use it, the better off we are.
Thanks. I just add that I can remember about 25 years ago organizing a seminar jointly with the Institute and the Canadian Bar Association, and it was on science in the courtroom. So by way of a footnote, this problem of how you handle science in a judicial or regulatory board setting isn't unique to ecosystems. It comes up all the time. Courts have always had to deal with this. How do you receive science? How do you receive technical evidence? It's a continuing problem, and this, I think, is probably just one aspect of it. I'd like to follow up on a thought that came up in an earlier question that had to do with boundaries, of the appropriate boundaries for ecosystems. And I mentioned in passing that some ecosystems, of course, are not respectful of political boundaries. And I'm just wondering if you have any thoughts in terms of what the ecosystem approach means for the future of how we manage transboundary relations. And I should say that in Canada there's very little, by the way, of law in terms of transboundary management of resources. But it does sort of suggest that maybe this is something we're going to have to think about a lot more in the future. But I'd like to have your comments on that.
Yeah, that's a tough question. They're all tough. And, I guess there are different sort of, ultimately, I guess it raises the question, should we ditch our, existing political jurisdictions and, and reform our jurisdictions along ecosystem lines? So the sort of the hardcore ecosystem proponents would, might suggest that. And it does remind me of it does bring up one of the sort of benefits of ecosystem approaches is that it sort of gets people to identify with the place where they live. It sort of gets them to think about, I'm not just a Canadian, or a North American, or, an Italian immigrant, or, whatever ethnic background. I am a person of the Bow River watershed, or I am a person of the prairies. And once you think along those lines, then the idea is that you start to be more concerned about what actually happens in your region, and there will be a sort of a greater ethic to actually protect it. So I assume, so okay, what are the, and I should say that there's a great, Gary Snyder, the famous beat poet and environmentalist, wrote a book, and I was trying to remember the name, but about, I think it's called something like Coming to the Watershed, and he sort of advocates this idea of watershed management as a way to get people to identify themselves as members of particular watersheds rather than as Californians where Gary Snyder lives, or Oregonians, wherever. But what are the chances of Alberta and Saskatchewan ditching their borders and becoming that's never going to happen, or unlikely to happen in our lifetime. So, what we're left with is, I suppose Alberta and Saskatchewan need to just keep getting together for periodic meetings and to talk about what's happening with the South Saskatchewan, North Saskatchewan. But I think there are all kinds of variations of sort of organizational levels.
I think, just as a footnote, that, Mike, this of course ties into the idea of place-based decision making, which is also an important theme in recent environmental law. And some of the interesting stuff that one sees now is citizens groups working across borders, sometimes more effectively than governments do. And I know, for example, in the Great Lakes, there's a very significant movement across the border where you have common citizen interests in the basin. So maybe the future is not so much governmental decision-making jointly as the role of citizens in promoting, or indeed pushing governments to a solution. I think, as I've said, we've seen that in the Great Lakes. Okay, if that is the final question then, we are right on time. And I'd like to thank Mike very much for taking us into ecosystems. Ecosystem management, of course, I would never use the term ecosystem approaches. So. Okay, our next speaker is going to return us to something that I think is more in the comfort zone of lawyers. It's, you know, the real law. And some of you may have memories, but I suspect they're relatively vague memories of public nuisance from your days taking tort law. And one of the implicit questions, well, explicit really in Chris Tollefson's talk, was what about the old common law? Has she got life in her yet? Now, the next speaker will address it in somewhat more elegant terms than that. But there is this question of, is there a continuing role for the common law? And to address that, we have someone who knows a lot about the common law and about the environment, and it's Professor Alistair Lucas of the Faculty of Law at the University of Calgary, and past Dean of the faculty, and way in the past, actually, Executive Director of our Institute. I hope you still remember those days fondly, Al. He is going to, as I said, take us back to these somewhat more traditional legal concepts.
Thanks, Owen. I have to be a little suspicious here about why I was asked to address this particular topic, and I'm a little troubled by some possibilities here. One of them being that I actually practiced in the old common law era. That makes me a little bit nervous. So I'm going to try in the presentation to be a little bit the archaeologist, you know, sifting through the debris of the common law, but also to try to look ahead a little bit in discussing common law doctrines around the idea of public nuisance. So we start with public nuisance. And the idea here is that public nuisance, and the Supreme Court of Canada addressed this in a non-environmental case in 1999, and the Chief Justice's summation of the common nuisance doctrine was, quote, any activity which unreasonably interferes with the public's interest in questions of health, safety, morality, comfort, or inconvenience, and she might have added health and environment. She's got health, but she didn't add environment. So that's the essence of the public nuisance doctrine, but historically, it actually did center on issues of land and property and related interests, and so the the pictures on the screen give you an idea of the context in which the doctrine of public nuisance developed. And many of the early cases had to do with public rights of way and interference with public rights of way. You know, tavern owners stopping the wagons to unload the kegs of beer in narrow streets kind of thing, and interfering with public rights of passage and rights of other shop owners and the like. So actions of that kind were common and are very much in the background of the development of the doctrine of public nuisance. Okay, so we start with this idea then of unreasonable interference. And the second part of this gets into what I've suggested in the paper are two tricky issues, okay, related to public nuisance. So one of them has to do with the fact that the doctrine here developed along two streams. One was a criminal stream, the idea of common nuisance as a crime. And we still have a crime of common nuisance in our criminal code, section 180 of our criminal code. But more or less in parallel with that developed the tort doctrine that I've mentioned already. And then intersecting with both of those doctrinal areas would be the tort of private nuisance. Okay, so you've got public-private, and then in terms of the idea of nuisance, you've got public nuisance and private nuisance with, as you'll see, some inevitable overlap. So that's the first issue. The crime versus tort doctrinal development. Secondly, you can see I really got off on hairdos here. 17th and 18th century hairdos. I just couldn't get over it. Anyway, this was my idea of a 17th century attorney general. I think he's actually a French courtier of the era, but never mind. Okay, so the second issue had to do with who can sue? Who has this public nuisance right? And it turns out that the right, maybe not surprisingly, is essentially in the Attorney General, given that it's public nuisance. There's a crime aspect as well, of which the Attorney General would be in charge as well. So much of the issue here revolves around to what extent can private parties take advantage of the common nuisance doctrine. Now, going back to what I said at the beginning about being an archaeologist of the common law of the environment, when I first began with environmental law in the late 60s and early 70s, public nuisance was central. There was a lot of discussion about public nuisance, and particularly about the standing aspect of it, the extent to which this doctrine could be used by private plaintiffs to initiate judicial proceedings to accomplish environmental objectives. Okay, so as far as private plaintiffs were concerned, there were two ways in which they could get into court. One is to go to the Attorney General and petition, right? Sir, madam, would you please lend your name as Attorney General to a relator action that I want to bring? Okay, and that then gets the proceeding into court. But as you'll appreciate, there are a whole lot of good reasons why attorneys general, no matter what the jurisdiction is, would be less than keen about lending the name of the Attorney General to environmental related actions. Okay, but that's one possibility. The second possibility concerns establishing that there has been special damage. That is, the plaintiff has suffered special damage in a way that doesn't make it a private nuisance. Okay, the idea is that it would still be pursued as a public nuisance claim, but that the plaintiff would have this claim because he or she could establish this kind of special damage that the authorities had mandated as the way in. So, and you'll notice I talk about rights of action, but also talk about standing, and it's a reflection again of the sort of mixed public and private law heritage of this doctrine. So, a case from Newfoundland around 1970 was of great interest. And you might wonder why a Newfoundland Supreme Court case would be of such great interest. And the reason is that it was one of the very few cases of public nuisance in which this special damage requirement was raised. And the court there affirmed, relying on old cases, mostly English cases, that the special damage had to be just that. It had to be special. They use the term peculiar. I know that can be a little bit ambiguous, but you get the idea. But perhaps most telling was the idea that the damage could not be common to the affected class, whether it's an affected class of property owners or an affected class of fishers, as it was in the Hickey case. Okay? It had to be damage that was special or peculiar to the individual plaintiff. All right? There was a hint in these cases that there was a negligence element to it as well, and I'll pick that up as we go along. Now, this idea of special peculiar damage not common to the affected class has been described by Professor Clark in his torts text as simply illogical, right? Because what it means is that in environmental terms, the broader the environmental damage, the more extensive the environmental damage, the less likely it's going to be that any particular plaintiff can establish damage not common to the affected class. It is, said Clark, simply illogical. And in the Canfor case, that was something that Justice Binney quoted in his judgment. Simply illogical. So, that brings us to Justice Binney's rant in the Canfor case. I'm a great connoisseur of rants. This one could have been improved with a little bit of editing, but nevertheless, that's what it amounted to. So Justice Binney in Canfor said, quoting Clark, that what has made public nuisance a peculiarly ineffective private law remedy is the special damages requirement. And then he went on and said, the reality is that it would be impractical in most of these environmental cases for individual members of the public to show sufficient quote-unquote special damage to mount a tort action having enough financial clout to serve the twin policy objectives of deterrence to wrongdoers and adequate compensation for their victims. So that was his rant, picking up on the illogical comment of Professor Clark. How do you get around this? How can this strange special damages requirement be dealt with? Well, legislatures have done this to a certain extent. An example is Ontario's Environmental Bill of Rights that simply particularizes what is required for standing to bring an action that is essentially a statutory action in the manner of a common law public nuisance action. But I suggest there may be a price. In Ontario's Environmental Bill of Rights, for example, a prospective plaintiff has to jump through a number of hoops, has to file a request with the appropriate Ontario government department for investigation, and then has to receive the investigation back, and only if the result could be characterized as unreasonable in some way, or if the government simply loses the request or takes forever to respond to it, only in those circumstances might an action be brought. So there has been something in the way of statutory reform, but this hasn't always been satisfactory either. One of the other questions about the common nuisance actions is remedial. So given that there is this public law history to the action, typically the Attorney General was seeking to enjoin whatever the activity was, right? The lead foundry in the 18th century that was spewing out contaminants, the pub owner that was blocking the thoroughfare, and so on, to enjoin that action, okay? But we've seen that in these environmental actions, very often the element of compensation is equally important. And there was a question, simply a doctrinal question, whether compensation, whether damages are actually available in this kind of action. So one of the things that Justice Binney and his colleagues did in the Canfor case is to make clear that in an appropriate case, compensation may be available. So he hasn't particularized, he hasn't gone into any detail, but he's opened a door. Okay? The other part of this, and I'll rush to conclusion here, is, okay, I started out being uncomfortable, being the archaeologist kind of sifting the debris, but now I'm going to get real excited because I'm going to start looking forward, being something of a futurist. Okay, it's hard to do that. I'll try. So the common nuisance idea has been viewed by a number of legal scholars as really one aspect of a potentially broader range of public rights with associated remedies that could be used in principle to address environmental harm. In other words, as an instrument, as only one among a number of potential instruments. So that then starts one thinking, well, what other like actions, what other like legal instruments are out there? And the idea of public trust and the idea of the government as fiduciary, having fiduciary obligations, has been noted and has been discussed in the academic literature. And for the first time in the Canfor case, the idea of action based on the government as fiduciary and the fiduciary obligations of government was discussed by the Supreme Court of Canada. So the Supreme Court raised the idea of public trust and raised along with that the idea that the idea of fiduciary responsibilities of government has been recognized in yet another area, and that is in Aboriginal law. And parenthetically, in the development of the public trust doctrine in the United States, that same analogy has been used. And if you look at some of the U.S. public trust decisions, you will see courts quite explicitly discussing the analogy of government's fiduciary obligation in relation to Aboriginal people. So, that led Justice Binnie in Canfor, and there'll be more discussion about the Canfor case, but Canfor, for those of you who haven't looked at it, had to do with a forest fire in British Columbia, a forest fire that was alleged to have been caused by the operating company, and the operations of the company were in Crown timber, okay, and they were operating under under timber license from the British Columbia government. And the forest fire that was alleged to have been the result of action or inaction and or negligence of the company included damage to Crown timber, but it also included damage to specifically protected areas in British Columbia. So the action was then brought by the Crown in right of British Columbia, primarily to recover damages, to recover compensation, but the time for injunction had, you can see by the flames on the screen, pretty much passed. So that was the context for the discussion by the Supreme Court in Canfor. Justice Binnie then went from his rant about the public nuisance doctrine, broadened that out, talked about the fiduciary obligation of government, and then raised some questions. Novel and important questions, he said. He would, wouldn't he? Novel and important questions. And these are the novel and important policy questions. And the one I want to focus on is the second question, whether or not there are enforceable fiduciary duties on the Crown. Questions 3 and 4, limits to the Crown's role, etc., and potential burden on private interests of this kind of what he described as indeterminate liability. Hey, that was the Canfor case, right? So the one that I want to focus on is fiduciary duties of the Crown, and particularly the public trust. So the public trust in origin seems to have its origins in Roman law, and some of these concepts came down into the English common law and can be seen in things like public rights of fishery, public rights of passage and access, water access, for example. Okay, but these are public rights, and with a corresponding protective duty in the Crown, right? So that's where the fiduciary aspect comes from. And in the U.S., this idea of public trust has been developed, and developed considerably, particularly since about 1970 in the environment and resources area, particularly water law, I think it's fair to say, and in relation to parks and protected areas in the United States. In Canada, a little more modest, to say the least. There really isn't a clear decision on the public trust, and there's some lower court decisions that that really go in the other direction. And the one that people who study environmental law always look at as a strange green case from Ontario, where the judge didn't get it at all. I don't know. I can't believe that David Estrin, who was counsel on that case, could have been less persuasive, but the judge didn't get the idea that this wasn't a private law trust, and he didn't need to talk about the three certainties and all of that. This was quite a different public law kind of concept. So at any rate, we've had that case, and not a whole lot of other action until some of the comments in the Canfor case that I've referred to. So what we're left with is what I've suggested is a kind of crack in the door. The Supreme Court's judgment in Canfor has raised the possibility that something like a public trust doctrine based on the idea of fiduciary duties in government might be recognized in Canada. They don't go into any detail, any kind of specifics. They open a little bit of a crack in the door, something that may be tempting as far as future litigants are concerned. So that's the futurist part of it. And just to summarize, public nuisance, an imperfect instrument, and especially because of the uncertainty about this special or peculiar damage element. But on the positive side, looking ahead, the idea of public nuisance and the way it was viewed by the Supreme Court in the Canfor case may give us a springboard for development of other kinds of public environmental law remedies, perhaps based on this idea of fiduciary duties in relation to the environment in government. Thank you.
You finished exactly on time. We'll again open the floor and also the virtual floor to questions. While you're writing them, I wonder if I can raise just sort of a very broad question, and it goes to public trust, but I think it goes to everything you're saying. At the heart of all of this, it seems to me, is a question of who gets to supervise the allocation of public resources. Is it just the government? Do we trust the government to do this, or what role does the public have? And that's often reflected in issues of standing, of course. And that has been a big issue for anyone in Alberta knows. There's a tug of war that's been going on between the courts and the regulators in terms of who gets standing, and I think that's probably been resolved. But if I can just put it as in a broad context, it seems to me that you might argue that one of the reasons public trust has been used the way it has in the United States is that people are a lot more suspicious of government there. It's been a lot more acceptable that you would question these guys who may have black helicopters or whatever, you know, that general suspicion of government. And historically, going right back to the Revolution, the idea that citizens should be able to keep a close eye on government, as opposed, of course, to the Canadian model. And it's interesting, I think, in that respect, that Canfor is odd because it's a situation where the Crown is invoking public trust. In the States, it's usually the other way around. It's private citizens dragging the government to court for not following through on their fiduciary obligations. So I wonder if there's just a difference in the legal culture here in terms of how we view government.
In in the early 70s, as I mentioned, public trust public nuisance actions and indeed the idea of public trust were hotly debated by eager young academics, mostly, maybe exclusively, okay? And at that time, it was thought that there was great promise in judicial actions and that judges could be persuaded to accept, in particular legal proceedings, some of these ideas about the development of the public nuisance action, broadening the idea of special damage, the idea of public trust, that judges could create law, okay? And in the United States at that time, that was actually going on. In Michigan, for example, some of Professor Joseph Sachs's activities, he was engaged with the legislature as well, produced the Michigan Environmental Protection Act, but there was litigation in which the courts really were going beyond what was then the leading edge. So it was thought there was huge potential in the courts. Well, in Canada, that just didn't pan out. In the United States, you had an explosion of litigation particularly under NEPA. And so the idea of using that route, the litigation route, became better accepted, and with citizen suit provisions built into environmental statutes, public interest environmental law groups really were set up on that basis to use the courts to try to address environmental issues. We've had none of that. We've had none of that in Canada. So what you see is that public interest environmental groups in Canada have pretty much abandoned the courts and given up on the idea that they're going to make startling new environmental law through civil actions or even through judicial review proceedings. One possibility, Owen, in response to your question, is that in Canada there have been other opportunities for public participation through things like public inquiries, but even in terms of the proceedings of regulatory tribunals. It's arguable that there have been greater opportunities for public participation in Canada, so that environmental interests, while saying, Canadian courts don't get it on the litigation side, are equally saying, but there are opportunities for us to actually participate actively in the regulatory context.
Okay, good. A question, to what extent, if any, does class action legislation ameliorate the illogic, as per the quote by Justice Binney, especially with respect to sufficient financial clout?
That's a possibility, and that has been alluded to in the academic literature to a certain extent, and there's some evidence in Quebec, and Paul, you may be able to comment on that, but there's some evidence in Quebec that class actions may be serving the same purpose or getting at the same kinds of issues. However, class actions have their own problems, right, in terms of the homogeneity of the class and the various issues that have arisen around class certification. So there's potential there, and that has been noted, but we don't have any real evidence yet that class actions are the answer.
Now the next question is one that we'll return to both this afternoon and tomorrow. And it does touch, however, on this. It's a practical aspect of damages on public land. And the question is, what are your thoughts on the quantification and valuation of environmental damages on public land used by Aboriginal communities with treaty or Aboriginal rights? And how do we quantify those damages? And again, we're going to hear more on this, but of course one of the problems this raises directly, and it's come up earlier, is the whole question of non-pecuniary values, especially traditional lifestyle and so forth. The quantification of damages is a fundamental irritant, I think, in many of these cases. And but this question is for you, so I'll let you speak to it.
Well, as you know, there's a group of economists that have been having a lot of fun with this with this issue of quantifying non-pecuniary benefits for decades and decades. That's part of it. And you alluded to another part, which is which really goes to evidence, I suppose, and that would be evidence that might come from Aboriginal communities about traditional values, for example, and I mean that raises quantification questions in itself, but you do get evidence, at least on the ground, in specific relation to the resource issues that are being addressed. So I'm not sure that I can add a whole lot. We haven't had that much experience in Canada with quantification,
No.
especially of the non-marketed benefits. A little bit of experience in the United States, and a lot more experience ongoing.
Yes.
Right?
A lot of joint work between psychologists and economists. In fact, there's a Nobel Prize that came out of all this literature. We will be returning to the whole question of quantification and valuation again later in the seminar, and this afternoon we'll also discuss specifically Aboriginal perspectives on environmental harm. If there are no other questions, however, we are virtually... Oh, yes. Thank you very much. You are critical of both the decision of Lerner in Green and Justice Binney's comments in Canfor. Do you not think that Justice Binney's judgment helps to set the stage for the evolution of the Canadian common law to protect public resources, especially given that we don't have citizen suits, and so forth in Canada?
I'm really enthusiastic about Canfor for that reason. That's the futurist part of my comments, and I think that's exactly right. That's the crack in the door that we now have, and we have a few guidelines from those comments. Don't get me wrong. I love rants. Okay, I wasn't used in a pejorative sense at all. It was more used in the the Peter Mercer. Or if anybody's seen Peter Mercer's show, where he, or not,
Rick Mercer, I think.
Rick Mercer
Yes.
is who I'm thinking of. Sorry, where he takes on a topic and then kind of waltzes down a graffiti-covered alley and has to put up with odd camera angles. That's more what I was thinking about. Okay, so I think that might actually help. Those comments by Justice Binney in Canfor might actually help. So I'm not skeptical at all. I'm by no means dismissing those comments. The Green case is the Green case. Let's forget it.
Okay, well, I think the picture of Justice Binney waltzing down a graffiti-covered alley is not a bad one to close on. Oh, we have one more question from the web. Oh, it's gonna have, that's okay. Yep. I'm a little tech unsavvy. I still refer to these as magic tablets, but apparently they've got other names. Could you please describe any relationship between the special damages provisions of public nuisance in relation to the test for determining standing before judicial boards? That is, only directly and adversely affected persons may intervene. This, of course, is something I was referring to earlier in terms of the Alberta context. Is there any opening for an NGO to intervene in a proceeding and allowed to argue matters of public interest that may not otherwise be heard? Well, there's certainly a good ERCB response to that, and since you're a member of the RCBL, I'll leave it to you.
Well, there's a very close relationship, and I won't refer to the ERCB cases, but rather to the Alberta Environmental Appeals Board cases. Sure. And if you look at the Alberta EAB decisions on standing, you'll find language that's very, very similar to the idea coming out of the public nuisance cases that the harm cannot be harm that is suffered broadly by a class of citizens. It has to be more specific to the individual who's claiming right to appeal to the Alberta Environmental Appeals Board. So the doctrine, if you like, that the EAB has developed in interpreting its legislation on standing is very, very similar to the classic common law doctrine.
Thank you very much. We are going to break for lunch, and we have indicated a number of lunch options for people on the net. We have a sumptuous virtual lunch for you. But the people in the room will have to get their own. I'd like to thank not just Al, but all our speakers this morning. It's been, for me, certainly fascinating. And we will return at, we're right on time, we'll return at 1:30, 13h30. Thank you. I'll have to check, okay? I think we will, just to be safe.